federal authority that we've talked about, the Supreme Court case from last year. You would then go to Rule 403. Looking at Rule 403, State versus Jones, that's 297 Georgia 156, Supreme Court case from last year. They pointed out and followed the federal authority that we've talked about for a while, but finally have a state Supreme Court case to follow it as well, that excluding evidence under 403 should be an extraordinary remedy which should be used sparingly. And they also hold that in close cases, a balance under 403 should be struck in the favor of admissibility. And following that up with U.S. versus Jernigan, which is 341 F. 3rd 1273. It's an 11th Circuit case from 2003. In that case, the defense argued that the evidence was inadmissible under 403. They held that Rule 404B is a rule of inclusion, and accordingly, 404B evidence, like other relevant evidence, should not be likely excluded when it is central to the state's case. In this case, proving motive when you have the murder of a child is central to the state's case. Your Honor, also point out to a case, United States versus Smith, in the packet that I gave Your Honor. That's 459 F. 3rd 1276. That's a 2006 11th Circuit case. That talked about photos of sexually related materials with adult women involving crimes against a child. In that case, and we'll talk in a second about the cases that Mr. Kilgore discussed, in that case there were acts with other adult women admitted in a case involving abuse of a child. In that case, though, it was admitted not just to show that he was into adult consensual sexual activity, it was for other purposes. And in that case, they did point out that, as Mr. Kilgore said, this is emotional, this is charged, quote, that the nature of the crime itself, and therefore the nature of the evidence tending to prove it, is emotionally charged, does not mean the prosecution must be deprived of its most probative evidence. In this case, that of motive, to show why somebody would do something so horrible. United States versus Sarragan, which is 568 Federal Appendix 711. It's an 11th Circuit case from 2014, holding that the greater the government's need for the evidence of intent, the more likely the probative value will outweigh the prejudice. And then just a couple of cases, they're in the stack talking about the admissibility of these acts when it's vital to counter the defense. Dolomon, D-O-L-O-M-O-N, and I believe it's Alagia, A-L-I-A-G-A. One thing regarding 403, first of all, the cases that Mr. Kilgore cited regarding adult pornography being introduced impermissibly in a child pornography case, that's a whole different ballgame. In those cases, the only purpose was to show some proclivity for looking at pornography. That's not what we're doing in this case, and I'll talk in a second about what we intend to do regarding 403 and limiting the nature of what we have in this case. One of the things we'll get to as far as the defense's motion that they seek to exclude would be adult pornography, not related to another person, not related to infidelity, not related to another purpose. The state is going to concede that. We're not going to try to put in just random searches for adult pornography that are not relevant to motive, intent, knowledge, and things of that nature. Additionally, in this case, as I said, the level and extent of this man's behavior and activity and showing how he felt about his family and his behaviors outside of it are extensive. There are thousands of messages, pictures left and right. I mean, I don't even know how to explain. If we wanted to put every picture and every text and every message that we have recovered, how long it would take to try this case. We're not going to do that. What we intend to do, and I'm sure there will be a point of diminishing returns when at trial, if this is allowed, the defense will say, okay, we've gone far enough under 403 on this, this is now cumulative. So I just want to let Your Honor know, while there may be thousands of chats and things like that, we do intend to limit it. And by limiting that, that lessens the prejudicial value and enhances the probative value. And additionally, the federal courts have also held that the limiting instruction also is another very important thing that can lessen any prejudicial value if Your Honor does admit it, to instruct the jury, look, you can only consider it for these limited purposes if you so find. So looking, Your Honor, at our 404B notice, the first particular subject matter we have talked about is the marital and family relationship and disharmony within those relationships. For all the purposes I've talked about earlier, we would seek to introduce evidence of that through numerous different ways, through chats, emails, phone calls, conversations, the defendant's own statements, things like that. In doing so, some of the general things that we would show through this, one, that while the defense pointed out some of the more self-serving statements the defendant would have made about his marriage and things like that, throughout this we would be introducing evidence as well through messages to people he knew, through messages to women that he didn't even know, that he was unhappy in his marriage, that he was unhappy in his sex life, that he would not leave Leanna because of Cooper, that he was the thing to keep him from leaving, that they were actually in counseling, marriage counseling, statements that he said that he hated being married, that he wanted to be single again, that he wanted to sleep with as many people as possible. The evidence would also show arguments as well, and even up to and on the day and in the minutes before he locked Cooper in that car, he was complaining about his wife, complaining when he wanted to go out with his friends. And then specifically saying that he wanted an escape from Cooper. Now, looking at, the defense didn't go into specifics regarding their motion about the things that they wanted to keep out. I'll try to limit my conversation as much as I can, but I do have to address their arguments. One, the first thing that they seek to limit seems to be an objection to any types of introduction of pictures and things like that of the defendant committing sexual acts and sending them to other women. Your Honor, this was actually raised by the defense, kind of their approach at the probable cause stage, where it was initially argued by them that this was just some kind of fantasy texting. He really didn't mean anything by this. It was just some play game, something like that. This is one step showing that, no, this wasn't just play. He's taking a step, first of all, to send pictures of his anatomy to other women. So I think that that is something we would seek to admit. Now, again, under 403, we would obviously seek to limit the nature and the cumulative effect of introducing things like that, but that is something we would hold would be admissible. Also, acts of prostitution. Your Honor, this is something, again, the defense raises claim, this is just fantasy texting. He really didn't mean it. He loved his family. He loved his son. He loved his life. Well, this shows the extent. Not only was he sexting, not only was he meeting up with other women in parking lots, he was actually seeking out and meeting up with prostitutes and paying for sex as recently as within a few weeks of Cooper's death. This was evidence he was unhappy in his marriage. Again, actions speak louder than words. They seek to exclude his participation in social media, these chats on Kick and Whisper and things of that nature. Judge, that's how he communicated with these other people, to start communications with them, to then possibly meet up with them, and then to engage in relationships with them. They also seek to keep out sexual exhibition. I think that relates to some of the other arguments they have. I think that would be admissible. Vulgar and profane stuff that was written. Your Honor, if it's stuff, there are things in this case that I would say when the police found it, it's not relevant. It may be vulgar, it may be profane, it may put him in a bad light. However, if it's not related to the motive and the other things of that nature, we're not going to go into certain things because there is a ton of it that could be construed to put him in a bad light. That is not relevant. We would, however, seek to introduce vulgar, profane stuff, things like that, language that is showing infidelity, disharmony in the marriage, and unhappiness with the family. As far as they also seek to keep out internet search history regarding pornography and personal ads. Again, as I said about the adult pornography, if it's regarding motive, we're not going to go into that. With personal ads, though, that actually will show the defendant looking for relationships, seeking them actively outside of his marriage, and then also finding other women to engage in relationships with. So we would seek to admit that. And then they seek to exclude private consensual activity or communications. I think that's just a general way of trying to cover everything that we've already talked about. Your Honor, the second general nature evidence line that we just touched on already is infidelity, extramarital relationships, defendant's desire to be with women outside of his marriage, and the attempted extramarital relationships and sexual communications with other women. First of all, it's necessary to explain how he's meeting these women, to go into how they met, chatting on these sites, chatting on these apps, to explain how they met them, then getting into what they actually talked about. The infidelity and extramarital relationships, 6 of these conversations with different women were going on the day of the incident, the day in question. Actually, there were others that were identified in addition to these people and interviewed. That's people who we would call to bring into court to testify about their relationships as well and things that he said or did not say. It's admissible, again, to show this is not just fantasy talk. And the evidence we would also show is that he met up with some of these people. When he wasn't constantly trying to meet up with women, he actually was successful and did. And some of these women that he came into contact with, he was closer than with others. He would tell them he loved them. He would get upset when their relationship would grow apart. He would send audio clips of himself playing guitar to 18-year-old girls. Things like that, showing that this relationship is growing and growing and growing. It wasn't just some fancy texting, meeting up in a Walmart parking lot in Eatonton, Georgia, unexpectedly where this girl is. It's something above and beyond that. And the defense talks about how, oh, here's these examples of how he says he loves his son, he's not really that unhappy with his wife. Some of these people, he never even told he had a wife. Some of these people, he never even told he had a kid. Some of these people, he lied to initially and told them, I have a fiance, and things of that nature. So to say that he was telling everybody under the sun that he loved his son, things of that nature, is not correct and is not reflected by the discovery. The third general nature evidence topic that we have listed is evidence regarding knowledge and research of the weather and the effects of heat on objects left out in the sun. There are several things we would intend to introduce in this vein. The video we've already talked about regarding the vet who was in the vehicle video on YouTube. He viewed 5 days before the actual act. An email from May 12th talking about the turnaround campaign, and it looks like it was from his daycare, and this is a month before the incident, talking about how this happened to a woman in Florida and how she left her child in the car and her child died. Images. There's an image we would introduce on his phone with gummy vitamins melted in a container, and the caption said something about, wow, must have gotten really hot outside in the car today. A week before this incident, the defendant thought it enough not to leave his guitar in the car and brought it into work. And people are like, what are you doing? I don't want to leave my guitar in the car so it could be warped. Showing his knowledge, showing absence of mistake. A Google search the day before the incident for why does it get hazy when it's hot outside? A weather search. Going on to the fourth topic, general evidence, we have stated that we would like to show state of mind regarding his child, children in general, and living a lifestyle free of the responsibilities of children. I know they're trying to soft pedal this whole thing about child free, but that's the thing. He went to the homepage of Child Free. Child Free is a website for people who want to live free of children, and then read 3 articles on that site, or at least clicked on them. But he made the conscious decision to go to and stay in a website called Child Free. How he felt about his child on the day in question about needing an escape. And the defense talked about, well, you know, there's stuff on here about him not liking abortion and things like that in commentary. Well, I would submit, and it's in the discovery, there are a lot of things that Mr. Harris said and did that were in complete contradiction to that belief as far as morals and things of that nature. So to say that that is somehow some exculpatory issue, I think is disingenuous. As I've spoken earlier, we talked about the beach. There's evidence that he did not want a vacation the month before this incident with his son. He wanted to go with just the adults. And things of that nature. The fifth topic would be defendant's state of mind regarding death in the months, weeks, and days leading up to the murder of Cooper. There are several searches are going on to Reddit on sites about unsolved murders and things like that, showing an interest in death and homicide and things of that nature leading up to the incident. And from his own Evernote notes, he made a note, took the time to make a note. It appears it would have been that Sunday, the 15th, right before church, and put in his phone an anatomy of temptation and wrote desire with a greater than symbol, sin, greater than symbol, death. 3 days before this incident. That is the type of evidence we would like to show under topic number 5. Topic number 6, we already discussed most of this. This is the financial status, employment leading up to it. I know we're leaving the life insurance. We have to approach you before or later at trial. If we get to that point, we think we've created a nexus for the admission, we will. In this particular situation, what we're looking for as well is about his state of mind leading up to it, how he was unhappy with his family, he was unhappy at home, how he was unhappy with his job too, leading up to the death of Cooper. And then topic 7 is just evidence showing the defendant's knowledge, research, and interest in law enforcement, criminal law, and the prison system. As you've seen, as you will see through his interview and things like that, he makes several strange explanations and things like that about how he refers to police officers. There actually is interest in law enforcement. A Reddit comment he made one time when there was a post about something in a fight, something of that nature with bikers. He commented, and this was in the, I believe, the month leading up to it, that how important it was to make sure you have independent witnesses in order to make. Also searches for statutes. He actually sent a screenshot to a younger girl while I was trying to convince her that it's perfectly legal for him to be sending pictures of his anatomy to her. And there was also a search for what prison is really like. Finally, in his interview, he talks about his law enforcement. He's very proud about his law enforcement background. He, we would assert, uses it in trying to talk to the police at the scene, and then talks about spending 5 years with the Tuscaloosa Police Department when he is talking to the Detective Stoddard. That's not entirely accurate. It looks like he was employed there for about 3 years, but it is relevant to that as far as the res gestae that day, in addition to his knowledge of the system and interviews and investigations. Your Honor, quite frankly, we don't even have to technically have a hearing on 404B under the new rules before we get to trial. However, I think, as we discussed earlier, it's wise to go ahead and bring these things up before Your Honor and have them ruled on beforehand, even though we may say that, you know, we think that this is intrinsic, it is circumstances around the crime and motive. So that's why we brought it to you, and then we had this specific response from the defense finally about the motion to exclude this particular type of evidence. So, Your Honor, I think we argued the legalities of motive, intrinsic evidence, and things like that in great detail back in October. I think the law and the cases I cited and provided, there were a ton more than Mr. Kilgore actually cited, but I think that was pretty comprehensive and states our position adequately and correctly. So we would ask you to consider and rule that the state be allowed to go into these other acts under these different topics as allowed by Rule 404B.
that sounds like Mr. Boring wants to get into the trial of the case exactly what I suggested, which was bad character evidence, unrelated, completely unrelated to the death of Cooper Harris. If you noticed, let me go back to the very first thing that I talked to the court about. No evidence in discovery demonstrating a willingness to do violence toward Cooper Harris. Didn't hear anything from Mr. Boring's presentation about that. No evidence in discovery of a history of neglect of Cooper Harris. Nothing about that. No evidence in the discovery of a history of indifference. Nothing about that. No evidence of a history of corporal punishment or physical abuse. No evidence of that. No mention of that. No evidence in the discovery of prior difficulties with Cooper Harris. And all of the instances that I point out to the court where Mr. Harris is communicating with these other acts individuals, well, the state's position as well. Anytime that he said anything favorable about his son, it was just self-serving. There was an ulterior motive. But yet when it's something that the state suggests supports its theory, oh no, he meant exactly what he said there. Goose and gander. They can't have it both ways. And that's exactly what they're trying to do. Everything that he says that I pointed out, ulterior motive there. Well, he was just like taking a puppy to the park. Yet anything he said that in any way suggests it supports their motive, well, he said it. Well, those were the words. He meant that. Now that part he meant. And I guess shame on Ross Harris for wanting a romantic weekend with his wife. I guess if you've got marital problems, that's the last thing you want to do is perhaps have an adult weekend and have a romantic weekend at the beach with your wife. So shame on him for that. This is nothing but bad character. This is exactly what we have pled, exactly what we told the court it was. And there's not a thing that Mr. Boring said to even suggest otherwise. We ask that you exclude all of this.
Oh. I think we've had arguments. None of yours.
Yes, Your Honor.
Is there anything else to be done today?
Nothing from the state.
I can't think of anything right now, Judge. Thank you for your time today.
Thank you all very much. Well argued and well presented. I appreciate it. A couple weeks.
Yeah, I was going to ask, Your Honor, how long you wanted us to, maybe 10 days?
I think 10 days.
I would ask for 2 weeks. I've got a briefing.
I don't have a problem with that.
Thank you.
All right, thank you.
Well, thank you very much.
Thank you.
Court's in recess.